All right, the red numbers say 10:40, so I am going to reconvene us to continue with the meeting. The next time the next section of the agenda is an opportunity for public comment. When Sarah sent out the information, people could comment in writing and we would post it. They could come in person and comment, or they could telephonically call in and comment. I'd like to first hear from anyone in the room who wishes to speak. I do ask that your comments focus on the work that we have at hand, which is looking at the WSBA structure and what recommendations, if any, we might be making to the Supreme Court. We haven't done this before, and so I don't actually have a process as to how long people should speak or how we'll do the questions. So we'll just see how this morning goes, and then perhaps at the end of the meeting we can talk about in the future what would work well for us or not work well for us. I, as chair, will do my best to be sure everyone has an opportunity to speak, as the opportunity to be heard, which is very important, and then we'll allow follow-up questions from the work group of the speaker if there are any, before I go on to the next speaker. I ask that those in the room who are speaking either come to the table or come to the stand-up microphone, whichever you would prefer. This is being recorded. I believe it is also currently being videocast, or whatever it's called, showing my age, that so people are watching and listening and will be able to watch later when it gets posted to the website. So is there anyone in the room who wishes to make comments to the comments, suggestions, thoughts? Please come up, sir. Thank you. That was Kevin. Kevin Michael Watley.
Yes, Kevin Michael Watley. And I have to tell you, in all sincerity, I am so inspired by each and every one of you here. Each and every one of you here. Because you are here mostly in a voluntary capacity. You are here voluntarily working for this work group structure meeting to look at how to proactively serve the idea of the bar, which I would like to reiterate is created by the Washington State's legislature by will of the people as an agency of the state. And its first burden of duty is first and foremost to the public, access to justice, protecting the integrity of the courts and the judicial system so that everybody can be seen as an equal under the law. And that's why I'm here today. I'm here today to help encourage and inspire and support you. I'm here to help and encourage and support the 145 people that work at the Washington State Bar, because they are just first and foremost people. They are people, and they work under the leadership and the direction that they are given. And if the leadership and the inherent system can preclude people from having access to justice, it is not their fault. It is only the system to which they are working in. So it's because of you that why I'm so inspired to be able to speak here, to be able to speak free from the burden of judgment, because I'm here to make two requests. And before I get to that request, I'm here to give a little bit of reasoning why I'm going to make that request. That, as I stated earlier, that I'm a member of the public, but I'm also a victim. And the last time that I spoke here at the bar was before the Board of Governors to support the mandatory malpractice insurance. Because as you are all aware, there's not a basic level of protection for the public. There's only 2 states that actually require it, and that is a basic safety net. But the reason why it's so important is because the status quo still provides for a system that still allows for victims to happen, like myself. So I'd like you to be a little bit curious and a little bit thoughtful and be free to ask me questions afterwards, because I would like to submit the bar file. The bar file that is painful to me because it's the reason why I'm a victim, and it's the reason why there's other victims of the same bar file. And it's not because we shared the same attorney. It's because we shared the same inaccess to justice that allowed our cases not to even make it to court. We lost our due process of law, even though this attorney was under the entire investigation. In fact, she signed a stipulation to a reprimand the same day that we were ordered to be in a federal court for a show cause hearing. And I'm the first person in history to have an accident on an airline, and I owe them because I was never given my due process of law. I was never given my day in court. And the reason why those civil liberties are so vital is that if you are given your day in court, you can still have right to appeal and appeal to the Supreme Court of Washington all the way up to the Supreme Court of this country. But if you are denied that access to justice, if you are denied your day in court, then there is no legal recourse for you, ever, when your course is this case dismissed with prejudice. That's why it's so important that we honor that great seal of Washington and have a little more diversity and inclusion and public voice here. I agree that Janus and Keller are very important topics, and it's very important to look at the First Amendment issues that's before it. But as this work group structure moves forward, it's important that we actually look at the public first, not just the 40,000 members. There's 7.5 million of us in the great state of Washington. 7.5 million. And that is the first and foremost duty of this bar, and it's the duty of the Supreme Court to be able to see everybody equal and have an equal access to justice. So when I give you these names of victims, they are similar to me. Ralph Munson, Cindy and Gary Allen, Lisa Cosgrove, they're similar to me that we didn't have our day in court, even though this attorney was under complete investigation. I submit to you to be thoughtful about removing the lawyer discipline system from the bar, not to take people's jobs or livelihoods away. But it is my request that we actually look at different systems of how to protect the public, and I submit that the most basic of things that we should do today is to write a letter to the Attorney General of Washington and ask for a review. It is this office who is in charge with protecting the people of Washington State. And I have every bit of the intention that their leadership can provide a comprehensive review, or at the very least offer recommendations to this structure group of how it can actually move forward on the best interests of the people. Because as like the first speaker spoke about from Nebraska, that there was concerns about a self-regulating bar just administering the CLEs. It's even more fearful to allow a bar, the same status quo that exists today, to still allow it to be able to discipline itself, discipline its attorneys. I invite you to be a little bit curious. I invite you to look at the bar file. I invite you to look at how victims make legitimate claims and they get nothing but redacted responses back. Even though that order of redaction happens 2 months after, they're still given not an opportunity to respond. I want you to look at this one bar file of how this one attorney was allowed to pick her own practice monitor, and yet was able to hide from the practice monitor her clients, like myself, and allows it to affect every level of the judiciary. Because now you have a federal court judge dismissing case with prejudice. You have superior court judges, bankruptcy judges. They all couldn't see the people. They couldn't see the people that were for them. And that's why I think it's very important that we look at the lawyer discipline system and how to be fair and impartial to the judiciary. Because my fear as the public member is that because the Supreme Court of Washington is responsible for disciplining attorneys, that also makes it highly susceptible and liable, because it's responsibility that they shouldn't have. It should be fair and impartial between all matters that come before the court. That if me or the victims were to feel it necessary to sue and be sued, that we might try to actually name the Supreme Court of Washington, only to have a thoughtful argument. So I'm not here today with arrows of accusations. I'm here today with olive branches of understanding. So please, think about that. Think about what's in the best interest of the public. Think about how we're going to organize a structure that can see all 7.5 million people of Washington so that the civil liberties and their due process law is preserved, that alleviates any burden upon the court system to be liable for any part of it. So I want to thank you for your time on this. I want to thank you again for your leadership on this, and I want to be very clear. I am not here to accuse anybody of anything. I am only here to demonstrate the process that's before you. I'm only here to help demonstrate and show the connections of how just one attorney with just one license to practice law can affect the judiciary at every different level and can have a multitude of clients not even allow their day in court while under the complete investigation of the bar, and allowed me to have my day in court superseded by their procedures first.
Thank you, Mr. Watley.
Thank you.
If you'd like to give me the file, I will accept it. And are there any questions from any of the work group members?
Like to know, be more than happy to answer.
Fred?
You said two things, and you said that you were going to make two requests, and
That's right. I forgot about my second one.
I understand the first one was, what I took it was to look to the public first, or look to protect the public, as I thought was your first
And
request.
to reach out to the Office of the Attorney General to do a review on behalf of the people, what's in the best interest to protect the public, whether it's to maintain the status quo or are there clear demonstrable patterns to where people don't have access to justice, and is in the best interest to recommend something else to the Supreme Court in order to protect the public.
With respect to the structure of the bar? Is that what you're saying?
With respect to the structure of the bar and as far as the lawyer discipline system.
Specifically lawyer discipline. Okay,
Right.
thank you.
The other request, which I didn't make, and is just a different kind of thoughtful request, that again, I believe in the mission of this charter, and I believe in us being a proactive state, a proactive judiciary, and proactive volunteers like yourself. That it's only because it's that kind of leadership before me that I think that I can say something here and not be judged by it. That my fear is the public, that we're trying to reorganize the bar and how to best serve the public and the actual 40,000 members, and yet there's only one seated that's been afforded to the public position. So I would like you to consider for discussion the possibility of opening up and amending the charter to allow for more pure public voices that don't work in the sphere of the law whatsoever, to allow for a little more social equity as far as being able to proactively lobby for the best institutions to protect us. That it is free for you to keep the status quo of your charter, but it's okay just to have those thoughtful dialogues on how to have it be a little more inclusive, to open it up a little bit more to the public for an equal access to a voice in the shaping the matter. So that was the second thing. So thank you for asking. And if there's any other questions, I'll be brief.
Thank you, Mr. Watley. I greatly appreciate your attendance as a member of the public and providing your input.
Thank you.
Others who wish to address the work group today who are present in the room? Yes, please, Lee Ripley.
Well, to give you a little bit of background for those of you who don't know me, from 1997 to 1994, I worked at the State Bar Association. The last 7 years, I was the Chief Disciplinary Counsel. Since I left the bar, I have been defense counsel. I applaud.
And you said 1994, but did you mean 2004?
No, 1994.
So when did you begin? Since you said you began in 1997.
No, I began in 1977.
Thank you.
So 77 to 94.
Thank you.
I worked at the bar. The last 7 years, I was Chief Disciplinary Counsel. And since that time, as many prosecutors do, I've moved to the defense side. I don't know the facts of this gentleman's case, who just stood up and talked to you. I'm not sure I disagree with him that the public protection should not be the number one thing, but my concern is that the idea that I don't want to get lost is the idea that the bar and the lawyers and the legal practitioners remain a self-regulating profession. I've seen the growth from 1977 to now of the system, and I think it does a good job. Could it do better? Yes, but any human institution can always do better. And I think that I just want to see that core concept continue to be honored in whatever differences you make. So,
Thank you. Any questions from the work group? Thank you, Lee. I appreciate it very much. Any other comments, suggestions, questions from those present in the room? All right. We also arranged that we would have people online be able to ask questions. I'll ask Dory if there are any pending at the moment.
So I don't see anyone posing a question to us electronically in chat or via email. But if there's anyone on the telephone participating who would like to address the group, now would be a good time.
Hearing telephone silence. If you're talking to us,
This
unmute.
is Alec.
Please, yes, thank you for unmuting. If you would identify yourself and make your comments.
Yeah, this is Alex Stevens.
Hi, Alec.
And my only comment, and I think it follows, I think the last question you asked Paula Littlewood, which was, do we continue on or what do we do? And she said, basically, better to be prepared than wait so that you can actually sort out your own future. I guess one of the things that I would hope that as our work is done, as the work of the work group is completed and vetted, et cetera, that we get ahead of what changes we would like the legislature to make to put us in the best position to then implement if we have to. And that would be my only comment.
Great. Any questions for Alex? Thank you, Governor Stevens. Anyone else on the phone? Hearing none, I am going to move us into our work group discussion. If we get anything online or if someone interrupts on the phone, I will take a break and allow that to continue because it was very important for us to provide this opportunity and also to hear